Welcome, everybody. We will wait another minute before starting the webinar. Okay, so good afternoon, everybody, and welcome to this AIPPI webinar. We have approximately 27 now participants, which is good news. My name is Thomas Widmer. I am an attorney at law with Lalive in Geneva in Switzerland. I'm also a member of the board of AIPPI Switzerland, and I will have the pleasure of moderating this webinar, which is organized by AIPPI Switzerland with the help and support of AIPPI International. Starting with a few words about AIPPI for those who know, for those of you who do not know AIPPI. So AIPPI stands for the International Association for the Protection of IP, intellectual property. It is the world's leading non-profit association dedicated to the development and improvement of laws for the protection of IP. AIPPI is actually based in Switzerland, in Zurich, and has over 8,000 members worldwide. As each year, AIPPI International held its annual congress. This year was in Yokohama in Japan in September, so 2 months back. And during this annual congress, AIPPI adopted 4 resolutions, which are obviously the subject of today's webinar. As you know, previous years, there's one resolution about patents, another one about trademarks, a third resolution about copyright, and a fourth about a general issue in the field of intellectual property. These resolutions are being sent to WIPO, the WTO, to patent and trademark offices around the world with the objective of developing international IP law and harmonizing national IP laws. So the objective of today's webinar is to provide a presentation of the corresponding Swiss reports and these 4 resolutions. Elsa, if you can put the slide about the housekeeping rules, please. Thank you very much. So a few housekeeping rules for you. So the webinar will be recorded. Please keep your microphone on mute for the duration of the webinar. There will be a 5-minute Q&A session after each presentation, during which you are all invited to ask your questions. You can just unmute yourself and ask your questions. Or if you prefer, you can use the tools which are displayed on this slide. If you encounter any technical problems, please send a message in the chat box to AIPPI events. And also there will be a brief survey after the webinar. Thank you very much for your feedback. So the webinar will last until 6:30 approximately. We have a distinguished panel of speakers today. We're very lucky to have a very diverse panel with one patent attorney, one in-house general counsel, actually, one WIPO officer, and one Swiss attorney at law. I will present each speaker just before their corresponding presentations. So without further ado, it is time for the first presentation regarding the resolution about patents. Compulsory licensing, which is a presentation which will be given by Oliver Jeker, that you now see on screen. Oliver is a Swiss and European patent attorney and a partner at Wrench, partner in Zurich. He studied chemistry in Zurich and at the Princeton University. And Oliver is also a tutor in the international section of the Center for International Intellectual Property Studies in Strasbourg. And he's also involved as an examiner for the Swiss patent attorney examination. So Oliver will present the Swiss reports and the resolution about patents and compulsory licensing. So Oliver, the floor is yours. Thank you.
Thank you, Thomas, for the kind introduction. So I will share my screen and you should see my slides in a few seconds. Can you see the slides? Very good, thank you. So welcome to today's presentation of AIPPI Resolution Q293 about compulsory licensing, which I present on behalf of the whole Swiss working group. So we briefly start with the report of the Swiss group. As with every study question, the first part of the work was to get an overview of the current situation in Switzerland. And we, the Swiss group, have found that Switzerland has actually a well-established legal regime regarding compulsory patent licensing, allowing non-exclusive licenses in several situations. And I put here a very brief overview. So the typical situations are dependent inventions, insufficient exploitation of an invention, or patent licenses in the interest of the public. There are also licenses available for the export of pharmaceutical products. And as a further legal basis, there is also the possibility under the Swiss Cartel Act to have a compulsory patent license for the elimination or desistance from a hindrance of competition. All the provisions which can be found in Swiss law are in compliance with the TRIPS agreement regarding compulsory licenses. And I'm especially referring here to Articles 31 and 31 bis TRIPS. The Swiss group has therefore come to the conclusion that the Swiss law regarding compulsory patent licenses is actually comprehensive. However, the practical significance of those licenses is very, very limited. So we could only identify a handful of decisions in the Swiss case law. Therefore, the Swiss group considers the current law and practice in Switzerland adequate, but we also support the clarification of certain aspects. For instance, the application of compulsory licenses to pending patent application or supplementary protection certificates. Furthermore, in view of the recent COVID-19 pandemic, the Swiss group would also support international harmonization, especially with regard to the discussions about waiver of the TRIPS agreement with regard to COVID-19 vaccines. And we believe that this would help should such a situation arise again in the future to react in a timely manner on situations of worldwide urgency. And if somebody is interested in further details, there is the whole report of the Swiss group in the October issue of this year's SIG. So going on to the resolution Q293, I would like to mention first some few general aspects. So first of all, this resolution is based on 38 reports which were received by national and regional groups of AIPPI and independent members. And the reporter general team has then compiled a summary report which can be found on the AIPPI website. And on this basis, the subject matter was further discussed at the AIPPI World Congress in Yokohama, first by a dedicated study committee, later in a plenary session, and eventually the resolution was adopted by the executive committee of AIPPI. Regarding the scope of the resolution, it is important to note that it focuses on compulsory licenses granted based on a specific overriding interest. So you may ask, what is a specific overriding interest? And you can also imagine that this was part of the discussion during the conference. And in the end, there was found consent that a specific overriding interest exists if there is a situation where a public interest rather than a private interest is at stake, such as a national or regional emergency or other circumstances of extreme urgency. So we can also say what is not within the focus of the resolution. These are compulsory license, for instance, in case of a dependent invention or in case of lack of working of an invention, or to simplify it even more, these are situations like we can find them in the Swiss Patent Act, like the license in the interest of the public, or also the compulsory license for the export of pharmaceutical products. The resolution is very clear that the TRIPS agreement remains the framework for compulsory licensing, also in an international setting, and that it remains of the utmost importance and should be used as the framework within which this resolution should be applied. However, looking at the different national reports, there was a finding that Article 31 and 31 bis TRIPS are implemented rather differently across the different jurisdictions, and therefore harmonization would be desirable to increase legal certainty and predictability. So for this presentation, I therefore took the relevant provisions of the TRIPS agreement and the resolution, and I had a look what actually does the resolution add, where does the resolution foster clarity over the TRIPS agreement, and I identified 5 aspects which I would like to briefly present here. So the first is the availability of compulsory license. Here the resolution clarified that compulsory licenses should only be available for granted patents and patent applications for which an injunction is available prior to grant. So maybe you might ask, patent application and there is an injunction. Apparently this is possible in Italy, and therefore this was also introduced due to a contribution of the Italian group. But generally, regarding the underlying principle of the resolution, one can say it's a criterion that an injunction is available, that also a compulsory license is available. So following this logic, compulsory licenses should also be available for all forms of patent term extensions, being patent term extensions as a sui generis intellectual property right, or also for supplementary protection certificates, and of course also for utility models, because also based off them an injunction is possible. But compulsory licenses should not be available for instance, a patent application which is in examination and for which no injunction is available. Then the right to be heard and the burden of proof. Here it's actually interesting to note that the TRIPS agreement is rather minimalistic in this regard, and the resolution now clarifies that the patentee should be informed beforehand and should have an opportunity to be heard by the granting authority before the grant of a compulsory license, and also that the applicant of a compulsory license has the burden of proof that the criteria for a compulsory license are actually met. With regard to this, the TRIPS agreement is silent. Then audit and reporting is also a new aspect introduced by the resolution. So the patentee should have a right to audit, and the compulsory licensee should have a duty to provide regular reports on the use under the license. And it should be also safeguarded that this audit and reporting are undertaken in accordance with the principles of confidentiality and impartiality. Then going on, we have the termination and cease in case of breach and damages. So compulsory licenses should be wholly or partially terminable in case of breach. And also damages should be available in such a situation for the patentee, and even fines can be imposed on the breaching party. And then last but not least, I already moved to the last point, which is rather important in my opinion. And this is that the resolution holds that there should be no compulsory tech transfer. So compulsory license only applies to patent rights, and the patentee should have no obligation to provide further materials like trade secrets, confidential information, secret know-how, or technical assistance or anything. So here it's interesting to remark that actually this was rather controversial in Yokohama until the very last day. So if you would have had a resolution on the second last day, it would be more or less the same text, but without the not here. So it was saying exactly the opposite. And it was really in the very last session where this was turned around. But especially for Switzerland, I believe this is a rather important point, because you can imagine, especially for the pharmaceutical industry, know-how is at least as important as patent rights, and having the duty to also reveal confidential information would go too far also in view of the Swiss group. So to sum up, I come to my conclusion. So one may conclude that AIPPI resolution Q293 clarifies many open points in the TRIPS agreement regarding compulsory licenses, and is largely in line with the current Swiss law and practice. And it can thus be seen as a leap forward regarding international harmonization. However, the scope of the resolution is rather limited, namely only to licenses in the interest of the public, and other situations remain unresolved, which might be of practical relevance. For instance, compulsory licenses in a situation where a patented invention is not used. So I would like to thank you everybody for your attention, and then I give back to Thomas for questions.
Thank you very much, Oliver, for this very interesting presentation, and congratulations. That's for the perfect timing. So everything was perfect. Thank you.
Thank you.
I open the floor to the audience for any questions that you may have to Oliver. So do not hesitate to just speak out using your microphone or using the tool that I mentioned at the beginning of the webinar. Do we have any questions from the audience? If we don't, I might have at least one for you, Oliver.
Okay.
You mentioned at the beginning of the presentation that when you worked on the Swiss report, you hardly identified any case law in Switzerland, and I think that you wrote on your slide that in Switzerland this was of very little practical significance. I think compulsory licensing. My question, which is a kind of a general one, but why do you think it is not often used? Is it just unuseful? Is it unknown? Or can you think of any reasons explaining that that very few people actually recourse to that tool?
So probably I would say, I mean, also in Switzerland, when you look at the more specific cases outside of a pandemic, and this is the compulsory license for for a dependent invention. So if you have a patented invention and there is an older patent, and you can only use your patented invention if you would infringe the older patent, and therefore you might have or might not have actually the right for a compulsory license. Or also if you want to use an invention which is actually not used by the patentee. I think generally, as an applicant for a compulsory license, you would have to prove or demonstrate to the court that there is actually an overriding interest, which is so strong that it overrides the exclusive right of the patentee. And I think generally in Switzerland, intellectual property rights, which are property rights, have a really high status. And in practice, it has been found almost impossible to convince a court that there actually is an overriding interest. So I think it's probably an instrument that is rarely used because normally people are aware that it's rather difficult to show this overriding interest. So actually I'm aware of only one case where a compulsory license was ever granted. This is the Pupitre d'Écolier, but this dates back to 1904. So it's a really old decision by the Swiss Supreme Court, but it's the only case the Swiss group could find. And then there are a few cases, maybe every 10 years you find a decision somewhere, but it's really rare, but probably parties have little confidence in this instrument.
Thank you very much. I see two hands up. First Milton and then Joshua. So Milton, you may ask a question.
Yes, hello, Thomas, Oliver. Thank you for the opportunity to ask this question. And thank you for the presentation, Oliver. Pretty clear about the resolution. And my question is about the last part, and it's always a polemic one. And the problem that we will have in the future related to people say, the expert says that it's a matter of time to face another pandemic situation. So once AIPPI is focused on delivering some kind of clear rules, and I'm really enthusiastic about that. I'm a member of the PCT standing committee of the AIPPI, and I really enjoy the meetings. My question is, do you think that AIPPI intends to follow on with this last part related to being mandatory or not mandatory to do the tech transfer together with the compulsory license of the patent involved on the issue? Or do you think that is solved? It's something, okay, let's pass to the next one. Since it was something that it was really debated, and it's just a question about how far wants AIPPI to go with this kind of issue. That's it. Okay, thank you.
That's a very good question. Thank you. So actually, as you can imagine, there has been a lot of discussion about this, and this was actually the proposal of the Dutch group. So the Dutch group was also rather vocal on this, and they were not in favor or against a compulsory tech transfer. They were rather neutral, but for them it was not a question of patent law actually, which is somehow true. So they took the position, this resolution is about patents, this question is not about patent law, so it should be discussed in a separate study question. So I have no answer to your question, considering that it actually found its way into the resolution at the end of the day. One could say, at least amongst this group which adopted this resolution, the topic was somehow decided. But you are right that there was not a clear, final and really educated decision on that. So it might well be possible that this could be a subject of a future study question. I would not exclude it. Yeah.
Thank you. And Joshua, it is your turn.
Thank you very much.
Thank you also from my side for the very clear and good presentation. And my question is regarding the international context. Like, is the Swiss framework more strict or more patentee friendly than other countries? And also from the clarity, is it better regulated or more clearly regulated than other countries?
That's also a good question. I would say it's rather balanced. So what we could see is really if you take the Swiss Patent Act and TRIPS, you see that the legislator has done a careful job and really make sure that all the requirements stipulated in TRIPS are respected. But I would really not go in either or the other direction. In my opinion, it's rather balanced, and you also see that the resolution goes clearly further. So of course, some aspects are also within the Swiss procedural law. Of course, the Swiss Patent Act is not standing alone somewhere in the landscape. At the end, these are civil proceedings before the Swiss Federal Patent Court, where many principles apply, but yeah, generally, I would say it's rather balanced. I would say, but really not going into either one or the other extreme.
Thank you for that clear answer.
Okay, so thank you very much, Oliver, and the audience for the questions. So this was a resolution about patents, and now moving on to the resolution about trademarks. Another very interesting topic about exhaustion of trademark rights. And to present this resolution, we have the chance of having with us Myrtha Hurtado Rivas, whom many of you already know because she's a very experienced IP lawyer. So Myrtha joined Nestlé a few years back as General Counsel for Brand and Marketing, Properties, Licensing, and Anti-Counterfeiting. And I think that is very recent, maybe as from the beginning of this month. Actually, I think Myrtha serves as General Counsel for Nestlé Waters and Premium Beverages. And Myrtha also founded Leaderching, a mentoring and mental health initiative. I see many posts on LinkedIn actually regarding both of your activities, Myrtha. So we're very happy to have you, Myrtha, and we look forward to seeing a presentation about the resolution on exhaustion of trademark rights. So the floor is yours.
Well, thanks so much, Thomas, for the kind words and the introduction. It's a pleasure to be here with me. I'm sorry for my voice. I'm a little bit under the weather. I hope you can still hear me well. And if not, please give me a sign. I'll try to speak up a little. So yes, as you just mentioned, at this World Congress in Yokohama, it was addressed the harmonization of rules on the exhaustion of trademark rights, right, under the first sale doctrine. And I'm happy to report that we were a whole bunch of Swiss lawyers that were on the national kind of working group to prepare input for that. And I'm also quite happy to report actually that we did kind of have a voice that was heard when we were in the discussions and negotiations to come to the final resolution. But I also must admit that the differences and the, I would say, big changes, so to say, were much more related to the how we wanted the resolution to be, and you'll see this in my slides. So nothing rocket science to report. I already give you this as a heads up, but I still walk you through the key items of the resolution and then what the difference were between the input of the Swiss national team that worked on that and what at the end I believe are kind of the biggest outcomes. So with that, next slide, please. So here, what I already mentioned, and here you see all the names of the smart people that contributed to the national input. And next slide, please. And so what are the key elements of the adopted resolution? Well, good to hear, as very often in APPI, a call for unified rules on exhaustion, because we realize how much it actually represents as a challenge when you don't have that and need to deal with multi-jurisdictional litigation, or even just when you need to manage a business that is based on different markets or just commercializes its products or services in different markets. One of the elements was what triggers exhaustion. And here, confirmation with transfer of ownership, with the trademark holder's consent. What type of consent must it be? It must be express or implied. And importantly, it can be also given after the fact. Contractual limits, agreements, or even practices cannot override exhaustion. And then we had a couple of examples on legitimate reasons to oppose further use. The well-known problem of alteration and impairment of goods, the harm of reputation of the brand, consumer confusion, deceptive marketing, repackaging without this being clear that it's repackaged goods, and defects in goods. Burden of proof, very important, as you know. Normally on party invoking exhaustion, but there is some instances where this may shift. And then as sustainability is an evergreen topic at the moment, we couldn't escape sustainability for this resolution either. But clearly, there are some exceptions possible, but I get to those later on the presentation. So next slide, please. So here's the highlights of the input of our team. And I will not read out or repeat everything because it was pretty much aligned, which was the outcome of the resolution. But I would say for the legitimate reasons, it was more context dependent. So we had discussions already around what type of alteration must take place. And the common understanding was that it had to be significant. So we were a bit more flexible and less restrictive than the resolution. Then for sustainability, very clearly also the position of the team was that for private use it's allowed, but that actually once the goods are altered, and even if that's done on demand, we know this well in the field of watches where there has been already some decisions, the sale of the altered goods should not be allowed. And then similar to what comes out in the resolution, the burden of proof is on the party invoking the exhaustion, but it can shift if the trademark holder casts a doubt on that. So next slide, please. And here, just a very quick overview, just to put side by side the key elements of the resolution and how our position was from a Swiss side, and then how it ended up. I have to say that one of the, most active discussions in Yokohama was about the fact that some countries wanted to have a more, I would say, level, the discussion was about the level of detail. So for instance, the Netherlands and others preferred flexibility, and we were part of those, right? A more context dependent approach, whereas France and Russia, for instance, wanted very clear and specific provisions, and the resolution went down the detail approach. As you can see, with respect to brand reputation, the position we had taken was that in many cases, it's not necessarily a trademark law issue. The adopted resolution kind of verbalizes this differently and explicitly points to a legitimate reason. Then also you can see the difference for repackaging and then for sustainability. And again, the same as for the first legitimate reasons point, the detail level is like flexible case by case, and then the others were more descriptive. So interesting enough, I think that also reflected a little bit the fact that in our discussions in the team, even though some of us had more detailed and wanted to have more clear guidance at the end, the common opinion of the Swiss team, which maybe is not surprising for Swiss, as we always kind of find a middle way, was to try to be more context dependent and flexible and have a case by case rule. Next slide, please. I wanted just to take a second to speak about the burden of proof, because that's a topic that comes up again and again, and that was discussed a little bit further during the the resolution debates that we had in Yokohama. So I already stated that the general principle is that the trademark, the party invoking the exhaustion should bear the burden of proof. But there is also clear understanding that the burden of proof can also shift, and that can be so in specific circumstances. It can be actually up to the trademark holder. And so there were two specific cases that were mentioned. First of all, when evidence is primarily within the control of the trademark holder, and I think that makes pretty much sense. And the other point that was discussed was where substantial risk of market partitioning if the burden remains with the alleged infringer. What is that? That was the overall kind of objective as usual, and I think there's nothing new for any of us, right? It's to ensure fairness and prevent antitrust practices or unjustified market barriers. And then I think what the resolution is trying to kind of propose and suggest that we lobby in favor of is really clarifying and harmonizing the approach between the different states. And it's trying to provide some practical guidance for courts and parties in cross-border disputes. Next slide, please. So here again, just a final overview of the key elements, and I will not go through that again because pretty much it's the same that we saw at the very beginning. And I think that was pretty much all I had. I just, as I mentioned, the adopted resolution is more detailed and more prescriptive, but I think it doesn't go as far as really encumbering our position or putting us in a difficult situation. The most significant changes are, and sorry if I'm repeating myself, it's really the greater detail, explicit listing of legitimate reasons, the stricter rules on commercialization of altered goods. So that's the kind of sustainability part. I think that's pretty much all from my side. Next slide, but I think those are pretty much the main items that we want to bring across, Thomas. As you see, not rocket science, as I mentioned, but I hope this was still insightful as to the work that was done. And again, a big thank you to all the colleagues that contributed to it.
Thank you, Myrtha. Thank you very, very much for your presentation. I know that you have a very busy schedule. I was wondering whether you have still a few minutes for questions, or you tell me.
I can take one question.
One question.
But then I have to jump.
So who wants to be the lucky one from the audience for one question to Myrtha about trademark exhaustion? Any question?
Topic is not as sexy as compulsory licensing, you know.
Still quite interesting from my from my point of view. Just maybe one very quick question coming from myself. One of the legitimate reasons, to prohibit further use is harm to brand reputation. Can you just try to explain in a few words what can it be? Just maybe give a concrete example in which this could be seen as a legitimate reason.
And I think, there's obviously no crystal clear example, but I would see whenever the alteration pushes the product in a different level of category of where you wanted to position it for commercialization, and if that ends up having an overall impact on your brand, I think that's when we have it. And let's kind of think about a hypothetical case where something in the luxury, because specifically there we have this problem right now where there's a lot of businesses that are opening where they actually are gonna kind of alter a watch to personalize it, or alter a very high-end luxury bag to personalize that one. If that's done either in a way that the quality doesn't respect anymore the expectations of your quality as the first manufacturer of the product, or if that's done specifically in the luxury field in a very tacky way, or even, let's say, with some obscene or demeaning words, like, you know, we can think about high-end luxury bags, them being, you know, stitched with some emblems or elements that are not aligned with the brand that was the original brand. So all of that could be a reason for you to say, actually, this is not what I meant. This is kind of disruptive to my own brand equity. I hope this gives a sense as to how it could be, but it's most of the cases, it's really about someone stating that the equity of the brand is higher, and that because it's been personalized or altered, it becomes less, or it impairs the brand equity or reduces the brand equity that it had, that you have spent decades to build up.
Very clear. Thank you very much, Myrtha. So thank you very much for your time and for your presentation.
You're so welcome. Sorry to not be able to stay. Wishing you all a nice friendship day. Bye.
Thank you very much. Goodbye, Myrtha. Goodbye. Okay. So now moving on to the copyright resolution about artificial intelligence and copyrights. And we have the pleasure of having a WIPO officer with us today in the person of Anna Andrijevic. Anna works in the IP and Frontier Technologies divisions of WIPO, where she contributes to projects at the intersection of AI and copyrights. She's also an affiliated researcher at the Digital Law Center at the University of Geneva, and a PhD candidate at the same university, where she's completing her dissertation on copyright issues arising at the input stage in the context of generative AI. So Anna, you seem to be very well suited for this presentation. So we look forward to hearing from you. Thank you.
Thank you very much. Thank you very much for this presentation. Just before starting, I have to say that none of the things I'm going to say in this presentation should be considered as WIPO's views on AI and copyright, because as you know, it's a very tricky topic and there's still a lot of open questions. And this will be very clear when you will see my presentation right now. So first of all, I just wanted to share the list of authors I had the pleasure to work with in the context of this report, starting with Boris Katsiflis, who is an attorney at NKF, Lucas Dalmelin, who is a partner at Hamburger, Tania Germont, who is a senior legal counsel at EPFL, Markus Kaiser, who is a partner at Times Attorneys, Sébastien Rago, who is an attorney at Iblum and Company AG, Fabian Wigger, who is a partner of Weinmann Zimmerli, and finally Raphael Zing, who is a partner at iPrime Rensch Kaelin AG. So very short table of content, but the only thing that I will do a little bit differently in comparison, I think, with the two first speakers is that I will go back a little bit in time, because I think it's telling a lot about how we have evolved since 2019, when we submitted the first report on AI and copyright, which, as you can see in the title, was focused on artificially generated works. So very much focused on the output. Just as a reminder, this was pre-Gen AI. This was just to bring you back in time, the kind of conversations we'd had back in 2019 were more about works such as Edmond de Bellamy, which had been just sold for $500,000 by Christie's, and this was a first ever occurrence. These kind of things. We had also the next Rembrandt, which was shown for the first time back in 2016. So we were quite far from what we have today, which is this whole new series of tools, Gen AI tools that we have now. So it's also interesting to compare these different documents, starting with the AIPPI resolution on copyright in AI. And just before jumping onto that, I wanted to share that the Swiss report is actually very much aligned with the resolution on lots of different aspects. And then we will just talk a little bit more about current practice and law in Switzerland, which is not covered in the AIPPI resolution on copyright and AI because it goes straight into part 2 and 3, which are listed here. So I highlighted the two main topics I will talk about with regard to the AIPPI resolution. And then part 1 will actually be talked about when we speak about the Swiss report. So starting with part 2, I think it's interesting to highlight that we have policy considerations and proposals for improvements of the group's current law that have been discussed. The first question that was asked, and it's an interesting one, and you also see some high rates of groups that were in favor of those, was about the improvement of current law practice relating to the use of copyrighted data to train AI models. So the first question was whether or not we should ask prior authorization to authors and right holders before using their works to train AI models. As you can see, 83% of the group agreed on the fact that there should be some improvement of current law practice on this topic. Same with regard to copyright exceptions. The majority of the groups also agreed that we need a certain level of improvement of current law or practice on this topic too. Switching to infringements of AI systems and outputs. This is also an interesting one for the Swiss group because we were directly quoted in the resolution. So as you can see, the majority of the groups here too, including Switzerland, reported that greater clarity is required to determine whether training on AI model on copyrighted data could amount to infringement. And our group was actually mentioned because we specifically emphasized that there is an interesting question that has to be focused on about a copy that is present in the AI model. If you are interested in the topic, you may have heard about two very interesting cases that were very recently released. So the first one is a UK case, Getty Images versus Stability AI, in which the court, the House of Lords, decided held that there isn't any copy in the AI model, whereas in the Gemma versus OpenAI case in Munich, here the court decided that there is actually a copy within the AI model. So here, this is typically one of those questions where we have a tricky understanding of the application of the technology to the law, and we don't know exactly how to understand whether or not there is a copy within the model. I don't believe there is so much discussions about whether it is a copy before that, but with regard to the model, this is a tricky one. And we mentioned that in our report, and we were quoted specifically on that. With regard to part 3 on proposals for harmonization, there were a few questions that were submitted to us, starting with the first one, which is, should the use of copyrighted data to train AI models be harmonized? So all groups considered that this is desirable, especially considering the cross-border nature of AI, which includes the fact that there are servers that are located in different jurisdictions, and also the training data comes from different authors from different countries. Then the second question, should the use of copyrighted data to train AI models require authorization from copyright holders? Here, 95% of the group said that they are in favor, highlighting the balance that is needed between the interests of authors and right holders on one side and the interest of AI developers on the other side. Two other questions that I will mention as part of part 3 of the resolution. Should there be special exceptions allowing the use of copyrighted data to train AI models? Here, 90% of the group support establishing such exception, but only to the extent that we have clear and limited conditions. And with regard to compensation, here again, 70% of the group are in favor, with several countries highlighting the potential role of collecting society, which is very much debated across the globe in administrating and negotiating licenses with AI developers. And the last question for this part 3, should AI providers be required to disclose the training data used to develop their AI systems? So the question of transparency. 85% of the group considered that such transparency obligations are desirable. However, the scope of such obligation was quite nuanced and remains uncertain. So as you can see, for instance, the German group was pushing for disclosing all the data, so for AI companies to disclose all the data they have used, whereas in Belgium, the Belgium group said that they would rather have summaries which is closer to what we have in the EU AI Act. So now we will go to the AIPPI Swiss report on copyright in AI, and I will go back to actually the first part of the AIPPI resolution, which wasn't discussed in the resolution simply because, again, they refer directly to national reports. So we'll just look at a few questions that are interesting and key, according to me, as part of the Swiss group. So, for instance, the following questions were asked with regard to the input stage. So does your current law practice contains law, rules, regulations, or case decisions specifically relating to the use of copyrighted data to train AI models? The answer is no. But there are currently discussions at the level of the Swiss parliament, as you may know. Second question, does the use of copyrighted data to train AI models have to be authorized by the copyright holder? Our answer to that was yes. This is according to Article 10 of the Swiss Copyright Act. The first paragraph is regarding the general use of copyrighted works, whereas the second paragraph lists a series of economic rights, including the right to reproduce, the right of reproduction, which is in Article 10, paragraph 2, letter A of our Swiss Copyright Act. Are there special exceptions to the use of copyrighted data to train AI models in Switzerland? The answer, as you may know, is no. But we do have a text data mining exceptions. And now the question is debated whether or not this should be extended to the use of protected works to train AI models. So far in comparison to, so as you may know, within the EU, there are two text and data mining exceptions, Article 3 and 4 of the DSM directive that entered into force back in 2019. Switzerland has one provision, which is Article 24D COPA, so Swiss Copyright Act, and it only focuses on one purpose, which is scientific research. Whereas within the EU, they have two different provisions for two different purposes. The first one is really just for scientific research with a limited number of beneficiaries, and Article 4 is a more general provision for all beneficiaries, but with other conditions and also for the purpose of text and data mining. In Switzerland, we have only one provision which is applicable to commercial and non-commercial entities, but only for a specific purpose, which is scientific research. So to the question whether or not this would be applicable, for instance, to OpenAI, the answer would be probably no, not under Article 24D COPA, because I don't believe we could say that there is actually a purpose which is strictly limited to scientific research. So here again, we actually, interestingly, we covered both input and output cases. So with regard to output aspects here, we had the following questions, and we will see it's interesting to compare with the 2019 Swiss report. So do the following cases pose potential risks of copyright infringement? So for instance, if the output contains some characteristics elements, the answer is yes, there is a risk of copyright infringement there. If the output mirrors the style of a protected work, does that pose an issue on the copyright law? The answer is no, simply because the style is not protected on the copyright law. And is the output automatically considered infringing? The answer is no. It would be a case-by-case assessment that we need to do. So as you can see on the output side, so there was a big part on the input side for this year's report on AI and copyright. We also have a series of questions on the output, but the questions are slightly different quite different actually, from the 2019 report. So here we have questions about risks of infringement arising from AI-generated outputs, liability for copyright infringement at the output stage, and also applicable sanctions. Whereas in the 2019 report that we had, which was strictly focused on the output stage, and here more specifically artificially generated works, the questions were more related to authorship, so human versus authorship, identification of the author, questions of ownership as well, and finally a focus on the criterion of originality, which is, as you may know, the criterion that you have to analyze on the copyright law. So in conclusion, the Swiss group concurs with the majority of views expressed in the 2025 AIPPI resolution on copyright and AI. It was part of these big numbers that we saw when I spoke about the AI resolution, sorry. So I would say that the Swiss group is actually very much aligned with the resolution. Several questions, however, remain unresolved, such as the conditions under which the use of protected works for AI training, which are the conditions that have to be present in an exception, for instance, for the use of protected works for AI training, the licensing regime that should apply, and also the extent of transparency obligations. And finally, again, interesting shift that we saw between the 2019 report and today's report, where we see a primary focus on AI-generated output for the 2019 report to an increased emphasis on input and training data in 2025. Thank you very much for your attention.
Thank you very much, Anna. Very interesting, again, a very efficient presentation about this hot topic in the field of IP. So I open the floor to anybody from the audience to ask any questions to Anna. I invite you to seize the opportunity because you have a very knowledgeable person to ask questions to regarding this very specific topic. Yes, Pascal.
Yes, I just wanted to ask whether you examined the question of possible collective management of copyright in such cases.
So there wasn't I reread the report today and also the resolution. So there was a discussion about the role of collecting societies, but there wasn't a specific question about it, if I'm not mistaken, in the questions that were submitted to the national report. So we haven't spoken about it much, but it's definitely a topic that is a hot topic and something that is very interesting to lots of countries. And from what I reread today in the resolution, several countries were really pushing for an important role of collecting societies, especially in dealing with licensing negotiations and things like that. But there weren't many more information. It was just mentioned, but it's interesting to see that there is a small consensus on that, at least in the resolution.
Thank you very much.
But it wasn't really analyzed in the Swiss report simply because we didn't get this question.
Okay.
Thank you for the question, Pascal. Do you have any other questions from the audience? Not for now, so I do have one for you, Anna. I think that the resolution basically says that there is, or there should be a transparency obligation, as you called it. Basically, if I understand it correctly, meaning that any provider of an AI system should disclose any copyrighted data which had been used for the training.
Mm-hmm.
How would that work concretely? Would that have to be provided upon request from whom, or just in a very general way? So here is the 50 billion data that we have used in our training, or I mean just a very realistic or very concrete question.
Yeah, so there isn't any. So in the reports, as I mentioned, actually there were several propositions, and the groups didn't agree on one. Some were pushing for to disclose everything. Some other groups were just sticking to the summaries, which is again something that is talked about in the EU AI Act. So from a very concrete perspective, I'm not sure how we could apply it very efficiently. However, I think it's important to keep in mind the burden that can be on the authors and right holders, because it's a lot of work to try to first identify as much as possible if your work has been used by the AI company or not. It's something that a lot of plaintiffs in the US, for instance, where we have more than 60 complaints, I think now, that have been filed, they have been struggling with that simply because the only way for a lot of these plaintiffs to identify whether or not their works have been used is to analyze the output, which is what the New York Times, for instance, did. But it's not a very efficient way, simply because we know that AI companies use filters at the output level. So that's why for some articles you will see, well, if we take specifically the case of the New York Times, some articles will go through in the output and you will find them verbatim, whereas in other cases you won't find them. So it's a good question. How do we do that? Do we force? It's a big burden on AI companies as well to see if it's really that job to share everything. But at the same time, we know that there's been a lot of infringement on that side. So concretely, in terms of the infrastructure of how they do that, they could do that. I'm not completely sure how it could be the most efficient. But it's also why the questions of licensing could be really important here, to try to push AI companies to do this job, at least to disclose as much as possible, so authors and right holders don't have to run after AI companies to know whether or not their works have been used. So I don't have a very clear answer, also because it's still something that is very much debated right now. And it's a tricky topic, also because a lot of AI companies simply don't want to disclose, considering that they put a lot of work in preparing this data too. So to them, it's not really a great opportunity to share everything, considering that first it will show that they have infringed, if they have, and most of the time it is clear that they have infringed copyrights in general. So I'm not sure I have a perfect answer. We really have this kind of balance that we have to find between AI companies and authors and AI and right holders, and that's also what we see from the resolution. It's globally what we understand from the resolution, that a balance has to be found between the two. But yeah, so sorry, I'm not sure I really came up with a clear answer, because honestly, I don't believe there is one.
Do not be sorry. Thank you very much for your answer. And we have another question from Joshua. Please go ahead.
Yes, thank you for this clear presentation. And it was very interesting to me, even though it's not my field. But I mean, for me, it's really interesting to see that in such a dynamic field and industry, the legal certainty is still so a step behind, let's say it like that. How does the industry like navigate so much uncertainty, so much legal uncertainty? I mean, are they just all infringing, or like rather asking for rather than asking for permission, they just go for it, or what's the overall strategy that can be observed in the industry?
So that's how it started, pretty much, yes. So the strategy was to infringe massively and not ask any questions, and to keep the data sets very and not to be very transparent about the databases, also because the first company that actually was transparent about the databases was, if I'm not mistaken, Stability AI, which was also the first company, one of the first companies that was sued, both in the UK and the US, notably by Getty Images, and what is interesting in this case, for instance, is that they did that. They were actually transparent about the data. And they worked with an NGO called Lion, which is based in Germany, and Lion actually prepared the data sets. So the data sets were just lists of URLs, basically. And then there is a collective artist that created a tool to identify more easily within this billions of data which images were present. So, and that's how some authors were able to identify, artists were able to identify that their images, for instance, were present in the data sets. That was the case in the Anderson case versus Stability AI in the US. But here the issue is that very quickly AI companies realized that there was a risk to actually disclose the kind of data they had in their data sets. So quickly after that, what we saw is that we had less and less information. Even OpenAI was interesting to see how open they were about lots of things, including the data sets, and how it switched very quickly. As of, I think, GPT-2 and 3, we didn't have much more information about the kind of data they were using. At first, they were really more transparent about it, and then it switched. So now what they're trying to do is to create a lot of different licenses, licensing agreements with new players. So if you look at the list of, for instance, if you take OpenAI, if you look at the list now of licensing agreements they have dozens of them with different parties. So that has been the strategy. So infringing a lot, but not showing too much, and now trying to find ways to deal with that through licensing agreements. But that works with some big players, for instance, the Wall Street Journal or Reddit or this kind of companies that can easily, because they're the right holders, can easily share the data with a company such as OpenAI. But then it's more complicated for an individual artist who doesn't know if his or her work is used by OpenAI. So we still have this challenge here. So these are the kind of tendencies that we have seen. So infringing massively and then trying to find solutions. And the most recent, for instance, agreement that we've seen, the settlement that we've seen, the biggest one is in the case Bartz versus Anthropic, where you might have seen that there was a settlement for 1.5 billion, which is the equivalent of $3,000 per author in this case. So that gives you an idea, and I hope I was clear in my answer.
Yes, very insightful. Thank you.
Well, thank you very much once again, Anna, for your presentation and for your time. Thank you, Pascal and Joshua, for your questions. It is now time to move on to the last resolution, which is about preliminary injunctions and requirements for compensating damage suffered by defendants. This is a resolution which will be presented by Adrienne Hennemann, who's a senior associate with Schellenberg Widmer dispute resolution team in Zurich. Adrienne studied law in Zurich and holds an LLM in competition, innovation, and information law from the New York University. Her experience includes working as a foreign attorney at a major New York law firm, clerking at the Commercial Court of Zurich, and serving as a substitute district judge in Zurich as well, I assume. So, Adrienne, the floor is yours. Thank you.
Thank you so much, Thomas. I'm happy to discuss the last resolution, the general issue, as Thomas told us at the beginning. I will focus on the different paragraphs of the resolution, and also try to give the Swiss perspective on these paragraphs. The report of the Swiss group was on preliminary injunctions and the requirements for compensating damages suffered by defendants. And this report was already published in SIC, so if you're interested in this topic, please feel free to read it there. First of all, I would like to thank all the members of the Swiss group who it was a pleasure to work with. This study question where I'm going to talk about is about the applicant's liability for compensating damages, and also about the standards and requirements for a court to set a sufficient bond, security, or undertaking. 43 national reports were submitted, and we heard that at the beginning from Oliver, I think. They were followed by a so-called summary report, and then there was a first draft resolution, and in the end, there was this final resolution, and we're going to talk about this final resolution now. And I'm going to walk you through paragraph by paragraph. So the first paragraph, and one of the most important, I think, of this general issue here, is that the applicant for a PI should be held liable for the enjoined party's damages if a PA is later determined to have been wrongfully granted, irrespective of proof of negligence, recklessness, or intent to harm. Under Swiss law, an applicant is generally liable for loss and damage caused by unjustified preliminary injunctions. However, if an applicant proves that the measures were applied for in good faith, then the court may reduce compensation or entirely release the applicant from liability. So you see here that the Swiss law is not in line with the resolution. In the summary report, there was already a statement that nearly half of the groups supported a strict liability. Other groups, however, supported a more nuanced approach that also takes into account, like the Swiss law, the applicant's good faith. And 1/3 of the groups supported a fault-based approach. Not surprisingly, the Swiss group was also divided on this topic, whether a strict liability should be implemented or not. Notably, in the first draft resolution, the last part, the irrespective of proof of negligence, recklessness, or intent to harm, was not in there. It was just later added into the resolution. A not controversial issue was that the award of damages should not be automatic, but needs an active request. That is more or less the same in Swiss law. Without a request, you won't get any damages. The monetary liability of the applicant should arise from wrongful issuance and, where applicable, enforcement of a PA, irrespective of whether the wrongful grant is due to non-infringement, invalidity, or another basis rendering PI wrongful. And paragraph 4 holds that holding a valid IP right and reasonably exercising it should not provide an exemption or safe harbor from liability of a PI, which is later lifted or reversed. In Swiss law, I have already mentioned this provision. It's more or less the same, but I just want to emphasize that Swiss law does not know any carve-out when it comes to infringement or invalidity. But what the applicant or what the defendant still can, or what still is possible is a safe harbor if you argue that you applied in good faith for a PAI. What I found interesting here is that in the first draft of the resolution, there was an additional statement in this section, and that read, the reason for lifting or reversing the PI should not be necessarily, but may lead to differences in assessing the applicant's monetary liability. And as you can see here, that was deleted. And this is also in line with the Swiss group's view that it is not justified to treat IP matters differently from other areas of law. The damage suffered by the joint party should be the predominant factor. That was uncontroversial also in the Swiss group. What is interesting here is that, again, the first draft of the resolution had another section in there. It mentioned that the court should not give weight to the intent or subjective state of mind of the applicant or enjoined party and should not consider proof of negligence, recklessness, or intent to harm. But that, as you see, that was deleted now here. Therefore, the subjective state of mind may be taken into account when it comes to the amount. So coming back to my first slide or paragraph 1, like there should be a strict liability, but however, the subjective elements still play a role when it comes to the applicants, to the amount that should be paid. The causal link that was uncontroversial among the Swiss group members and also in the summary report, it was mentioned that almost all groups require such a link. Same applies to the failure to mitigate damages. It was uncontroversial in the Swiss group that this exists. You can see here in case of damages that were caused or extirpated by conduct attributable to or fault of the party claiming damages, the court may reduce the amount of damages to be awarded or dismiss the damages claim. So it was uncontroversial among the Swiss group and also the at the Congress that the failure to mitigate damages may have an impact on the amount finally awarded. The damage award should be based upon actual damages, including lost profits, sustained by the enjoined party, and also encompass legal costs. Under Swiss law, typically the defendant claims compensation for pre-procedural expenses not covered by the cost allocations, lost profits, reputational harm, and damages resulting from delays. So what is interesting here is that in the first resolution, the notion the notion lost profits, including lost profits, was not yet included, but here it is now in the resolution. And I can imagine this is because the different countries do not all have the same opinion of what actually is an actual damage. So it's to get a clear picture of what we are really talking about here. Coming now to the second part, the first part was about the liability, and the second part is about the question of guarantees. An applicant may be required at the discretion of the court or relevant authority to provide an adequate guarantee at the time of issuance or enforcement of API. As you see, under Swiss law, the court may make the PI conditional on the payment of a security by the applicant if it is anticipated that the measures may cause damage to the defendant. So we see Swiss law is in line here with the resolution. What I found particularly interesting is that this was a debated topic, that the summary report stated that 70% of the groups believed that specific standards or requirements should guide courts, but they caution against removing judicial discretion, particularly where requiring high-value bonds may adversely affect legitimate enforcement actions. So in the first version of the draft resolution, the notion discretion was not in there, but now, as you can see, it was important that the court still has the discretion to decide whether it wants to have a guarantee or not. And the Swiss group was also aligned here that it thinks that it is important that such a guarantee should not be mandatory. When it comes about the amount of the guarantee, it was uncontroversial among the Swiss group members, but also during the resolution that this should be calculated on a case-by-case basis, and that the important factor should be the potential harm that will likely be suffered by the enjoined party. And the Swiss group also thinks that this is the way it should work. And Swiss law also does not know a preset amount, and ultimately it lies in the discretion of the court, the amount it wants to set. What I think also very important or interesting is what has not been resolved in this resolution. And here, as you can see, the issue of a counter guarantee from the defendant to suspend the PI has not been resolved. In the first draft of the resolution, there was the following section: a counter guarantee issued by the enjoined or to be enjoined party may be permitted on a case-by-case basis upon consideration by the court or relevant authority and should not depend on applicant's consent. As I said, this paragraph 12 did not make it into the resolution. Swiss law knows this principle. If a defendant provides an adequate security, the court may refrain upon defendant's request from ordering preliminary measures. However, the Swiss group was reluctant and mentioned that the adequacy of a security should be assumed only with caution, as it rarely provides a full reparation of the harm that the PA seeks to avoid, and monetary security is generally not considered sufficient. So the Swiss group was rather skeptical here. And what I also found interesting here is that in the summary report, I found the statement that there was very strong support for accepting these counter guarantees from defendants to suspend the PI, but apparently this support was not that strong, or was at least gone when it came to the final resolution. So it was heavily debated, I heard, and in the end, it did not make it into the resolution. I found it very interesting to discuss these issues involved with the study questions, and should you have any questions, please feel free to ask.
Thank you very much, Adrienne. So does anybody have a question regarding this last resolution? Does not seem to be the case for now. So as you could expect, Adrienne, I do have one for you. Actually, that just came up to my mind, actually hearing from, listening to you. I was wondering whether the resolution actually makes any difference between, ex parte or inter partes preliminary injunction. Because again, not having really thought that through, but I could assume that, if you file and if you obtain an injunction without your adverse party to be, having the right to be heard, you may expect to be liable then if when the proceedings become contradictory, when the judge changes its mind, then you may have to indemnify your adverse party. But then if you file your request for an injunction and the proceedings are contradictory, and your adverse party has the right to be heard and to file arguments, and you manage to convince the judge, then if down the road, 2 years down the road, another judge on the merits takes another view, that you have to indemnify your adverse party seems a bit, at least, different, I would say. So just a general question, do you remember, or does the resolution make any difference between these two types of preliminary injunctions?
That's a very interesting question. And when I was reading again, like the guidelines before we started working, there were questions concerning the ex parte or inter partes proceedings, but in the end, I couldn't see that they made it into the resolution. So, but I could imagine, but that's only my opinion, that all these procedural issues, normally they tend to have, there are a lot of different national laws, and harmonization is really difficult. And also when it comes to what is a ex parte measure, and even after the ex parte measure has been issued, how is the proceeding gonna proceed? That's so different from each country to another. So I think that's why in the end they were just talking about the ex parte, the inter partes decisions in the resolution.
Okay, makes sense. Yes, we have a question from the audience. Please go ahead, Felix. You're muted.
On mute.
Can you hear me now?
Yes.
Thank you for your interesting presentation. I'm a little bit concerned about this concept of strict liability, because in the specific area, a preliminary injunction is frequently the only way to have an effective protection. With this system, where you have strict liability without any form of culpa, I think this measure becomes hardly viable for a single artist, a single person, a normal person. This is something for the big corporations when they fight against each other, but it seems to me that it becomes hardly viable for the guy on the main street. So I have this concern because we in civil law we usually have the concept of negligence, of culpa, of some kind of wrongdoing, but here that seems not to be necessary.
That's an interesting point. That's exactly the issue that we already discussed in the Swiss group, and the Swiss group was divided on that issue, and as well the resolution. You have seen it, the intent. It switched from at the beginning. The resolution now says that you have the strict liability. It doesn't matter what was your intention, and even if you have like your right to ask for a PI, but my impression was that now when it comes to calculating damages, you may, at the court's discretion, like the damages will likely not be in the whole amount that the defendant has suffered, but you will then like get a kind of a reduction of the damages amount. But like your concern, I understand this, and we discussed this also in the group, that if you really have a strict liability, then you have the issue that sometimes you may, as a small company, no longer deem it viable to actually seek a PI, and that would be rather not good normally, because then you can no longer like, you don't have this injunctive relief where you can like within some days you get the situation straight for a moment. But on the other side, looking from the side of the defendant, there is also the possibility that such a injunctive relief can be misused, for example, by a competitor or by a huge company. So it's on balance, it's very difficult topic. But what we discussed in the Swiss group is that apparently in Germany, but please correct me if I'm wrong when somebody from Germany is here, that in Germany they have the strict liability scheme, but they don't have any issues, like we don't have any PIs anymore. But it's an interesting topic, and yeah, it's hard. And I think that's exactly what came out in this resolution, that in the end, it's all a case by case determination by the court. That's more or less, that's the whole thing about this issue.
Thank you very much.
Welcome.
Thank you once again, Adrienne, and thank you for the question. Yes, it is it. Elsa, if you can put back the slide, the final slide. So for the 21 remaining participants that you are. So thank you very much for the participants. Thank you very much for the speakers. Obviously, I have just one last information to convey regarding the next AIPPI midterm meeting, which will take place in February, I think, early February 2026 in Marrakesh, Morocco. This being said, this is it. We're wrapping up. So thank you very much, everybody, and have a good evening. Goodbye.